Afternoon and welcome. I join you from Sicily, an island around which Homer set several of Odysseus' trials at sea, at the edge of the world as the Mediterranean then imagined it. Antarctica lay far beyond that edge, and no European saw the continent until the 19th century. It is now central to the stability of the climate the rest of us live in. I am Ayman Cherkaoui, Deputy Chair of the IUCN Work Commission on Environmental Law and Director of the Hassan II International Center for Environmental Training in Morocco, the academic arm of the Mohammed VI Foundation for Environmental Protection, chaired by Her Highness Princess Al Hassan. Environmental capacity building is at the core of the center's mandate, and today's session contributes directly to it. It is a privilege to open this installment of our series, The Transformative Power of Law, Addressing Global Environmental Challenges. Before turning to Antarctica, let me briefly situate today's discussion within IUCN and WCEL. The International Union for Conservation of Nature, founded in 1948, is the only global body that brings states, governmental agencies, non-governmental organizations, and indigenous peoples organizations into a single membership with the authority to adopt common policy. Its experts commissions carry that policy into practice. The Work Commission on Environmental Law is the union's network of environmental law specialists, more than 1,500 of them all over the world, and its purpose is to advance the environmental rule of law, the development of legal concepts and instruments, and their use by legislators, schools, and negotiators. When IUCN members adopt positions on questions of environmental law, WCEL plays a central role in developing the legal implications and supporting their application in policy and practice. Today's session is convened by the Commission's Right of Nature Specialist Group, and I want to thank its chair and deputy chair and the members of that specialist group for organizing it. Throughout the series, we have asked a simple but demanding question. What can law actually change? Today, we put that question to the place where the answer is perhaps least obvious and perhaps most consequential. Antarctica covers roughly a tenth of the Earth's land surface. It drives ocean circulation, holds around 70% of the world's fresh water and about 90% of its ice, and conditions the climates of regions thousands of kilometers away. Almost no one lives there. Almost everyone depends on it. This legal situation is equally singular. Before the Antarctic Treaty, the American polar explorer Richard Byrd expressed his hope, beginning of quote. I am hopeful that Antarctica, in its symbolic robe of white, will shine forth as a continent of peace, as nations working together there in the cause of science set an example of international cooperation. End of quote. Byrd died in 1957. He did not live to see that hope substantially realized. The Antarctic Treaty, signed in 1959, suspended sovereignty disputes and made the continent a space for peace and science. The Environmental Protocol later recognized Antarctica as a natural reserve devoted to peace and science and established the protection of its intrinsic value, together with wilderness and aesthetic values as a guiding principle under Article 3. It was and remains a significant achievement of international law. What Byrd could not anticipate is that the gravest danger to Antarctica would arrive from outside it. Two limits, among others, are now visible. The first is jurisdictional. The principal threats to Antarctica now originate largely outside the treaty area, in emissions and pressures produced and regulated elsewhere. The system was not designed to reach them. The second is procedural. Consensus decision-making across the system allows a single state to prevent the adoption of measures supported by scientific evidence, as repeated proposals for marine protected areas have shown within CCAMLR, the Convention on the Conservation of Antarctic Marine Living Resources. This is the gap into which today's discussion falls. At the 2025 IUCN World Conservation Congress in Abu Dhabi, IUCN members adopted Resolution 54, Recognition of the Rights of Antarctica. Our first speakers will explain what that resolution proposes and where it may lead. Resolution 54 did not arrive in isolation. It's alongside other resolutions adopted at the same Congress, notably Resolutions 53, 55, 66, and 69 inter alia, on rights of nature in territories, on the ocean, on rivers, and on ecological recovery. And it continues a line running from Resolution 100 of the 2012 Congress, which called on the Union to treat the rights of nature as a key element of its planning, action, and assessment, to Resolution 81 of the 2016 Congress, which invited support for the rights of nature and for the instruments that would recognize them. All five of those 2025 resolutions are now being taken forward to the work program of the Rights of Nature Specialist Group, which I thank again, and that has evolved from a task force into a specialist group during the current quadrennium. and which has taken up Antarctica under a project on rights of nature and the global commons. What began as a general principle within the Union is increasingly being translated into legal approaches for specific ecological systems, rivers, ocean, and now Antarctica. I want to frame three questions for the hour ahead. I will not attempt to answer them. The first concerns duties. Recognizing Antarctica as a rights holder implies obligations owed to it. Who bears those obligations? What is their consent? And by what standards is compliance assessed? The second concerns representation. Antarctica's condition is determined in forms where it has no standing: climate negotiations, fisheries management, ocean governance. Legal representation is the operative element of any rights framework. Without it, recognition remains declaratory. The third concerns the relationship with the existing regime. The question is whether rights recognition sits alongside the Antarctic Treaty System as a complement, or whether it functions as a corrective. Recognition without institutional consequence is a statement. Recognition accompanied by duty, standing, and representation is a legal regime. Distinguishing between the two is, I believe, inter alia, the work of this session. We have a demanding hour ahead. Professor Philippe Cullet and Dr. Bhati, Chair and Deputy Chair, WCEL Rights of Nature Species Group, will open on the 2025 resolution and what follows from it. Dr. Ricardo Roura will examine the current regime for protecting Antarctica's intrinsic values and its future prospects. Linda Sheehan will address intrinsic value and inherent rights, and I believe she has very photogenic pictures to go alongside her presentation. Cormac Cullinan will speak to the relationship between the Antarctic Treaty System and the Antarctic Declaration. We'll then have about 15 minutes for questions, hopefully, if we all stick to time. However, I encourage participants to use the Q&A function throughout rather than waiting for the end. Professor Cullet, Dr. Bhati, this floor is yours. Thank you very much, and thank you, Roberto, for facilitating all of this brilliantly. Thank you.
Thank you very much. Okay, I'll fine. We could not check the sharing function before, so I will not have a PowerPoint. But in any case, it does not matter. So we'll divide the next few minutes between myself and Dr. Bhati to introduce in a few seconds the rights of nature mandate that the specialist group has, and then the specific topic we have today. So in 2025 at the World Conservation Congress, as we just heard, there were several rights of nature resolutions that were adopted after a 13-year gap. So really something happened in 2025. This includes general resolutions on nature in specific countries and territories. Overall, one resolution focusing specifically on rivers, so parts of nature, one on the seas, and each of them provides a different entry point for rights of nature, from the local to the comprehensive to the global commons. Now, the additional resolution that interests us specifically today is the one that was already mentioned on the recognition of the rights of Antarctica. It gives us a context of Antarctica as both land and sea, so combining several of the dimensions that are contained in the other resolutions. It also, interestingly, does something that not all the other resolutions do, because they probably can't, is acknowledge the existence of a complex legal regime under the ATS, which underlies the kind of discussion that we're having today. So we're not starting from scratch, we're discussing rights of nature in the context of something that already exists. The mandate that the resolution gave to the World Commission on Environmental Law and IUCN generally is to evaluate the concept of fundamental rights of Antarctica and corresponding duties of humans, and to protect the intrinsic value of Antarctica and its dependent associated ecosystems. So as part of this mandate, this webinar seeks to discuss some of the questions arriving in more detail, and that includes what it means to recognize these rights and who may represent both Antarctica and Antarctic beings in decision-makings, in international fora, in legal proceedings. What are the duties that would follow for humans, for states and institutions? Can existing non-measured uses, such as the mining moratorium, prohibitions on certain forms of pollutions, as well as others, serve as some of the practical building blocks for recognizing the rights of Antarctica, so really building on the existing legal regime. And lastly, examine whether some of the exceptions, such as the scientific activity, tourism exceptions, reveal the need for stronger representation and a rights-based framework, so to move from where we are to something new. I'll now pass on to Dr. Bhati.
Thank you, Philippe. Thank you, Ayman and Philippe, and thank you to all the colleagues and participants for joining us today. I'll add just a few reflections to build on what Philippe has outlined. The Resolution 54 of the Rights of Antarctica is important for today's discussion and in general because it situates rights of Antarctica within IUCN's broader work on rights of nature resolutions passed in 2025, while also recognizing the particular legal and ecological context of Antarctica and the Southern Ocean. Most importantly, it acknowledges the importance of the Antarctic Treaty System, including the Madrid Protocol, as well as the Commission for the Conservation of Antarctic Marine Living Resources, and the existing commitments to environment protection, intrinsic values, wilderness, peace, and science. At the same time, it invites IUCN, its commissions, members, and partners to consider what it would mean to evaluate the fundamental rights of Antarctica together with corresponding duties of humans. This is where Antarctica becomes a particularly challenging and thought-provoking case, especially for rights of nature. Many rights of nature examples, as we all aware of, concerns basically rivers, forests, mountains, or ecosystems within domestic legal systems, often closely linked to indigenous people or local communities. Antarctica, however, is different. It is not within a single domestic jurisdiction, has no permanent indigenous or local human community in the same way, and is governed through a distinctive international regime. At the same time, it is central to climate stability, ocean circulation, biodiversity, and planetary ecological processes, and is affected by activities both within and beyond the Antarctic region, including climate change, pollution, illegal, unreported, and unregulated fishing. This makes representation a central issue. If Antarctica is to be understood as right holders, its interests can't be reduced to human preferences, political convenience, or economic values. They may need to be approached through ecological integrity, precautions, scientific knowledge, cultural plurality, ethical guardianship, intergenerational responsibilities, and duties owed to Antarctica itself. And this is where rights of nature may add something important. It can help clarify the duties that flow from Antarctica's intrinsic values and strengthen the representation of Antarctica's interests in decisions affecting its future. With that framing, we are very fortunate to have three excellent speakers. Dr. Ricardo Roura, he is a senior advisor at the Antarctic and Southern Ocean Coalition, will help us understand the current regime and future prospects for protecting Antarctica's intrinsic value. Then we have Linda Sheehan, Executive Director of Environment Now, will speak to intrinsic values and inherent rights. And then finally, Cormac, Executive Director of the Wild Law Institute, will then address the relationship between the Antarctic Treaty System and the Antarctica Declarations. I now give the floor to Dr. Ricardo. Thank you.
Good afternoon, good morning, everybody. Thank you for having me here today. I would like to share some personal reflections on Antarctica's intrinsic value as reflected in the mandate of as recognized in the 1991 Protocol on Environmental Protection to the Antarctic Treaty. Just to summarize, intrinsic value is a value something has for itself, independent of any use or benefit we get from it, which is its instrumental value. As a practitioner and witness of Antarctic conservation in Antarctica and in the Antarctic Treaty System, I am interested in how Antarctica's intrinsic value can be protected in practice now and in the future. And so I would like to make a few points. The first, as we heard already, the protocol protects Antarctica's intrinsic value, and that's remarkable. It is remarkable, it's unusual, and it protects not just intrinsic value, but also wilderness and aesthetic values, and it's valued also for scientific research. The protocol, however, doesn't define these values, but treaty parties have applied them operationally, if somewhat tangentially. For example, in designated Antarctic specially protected areas, there has been some areas designated in part because of their wilderness or aesthetic values. It has been used also in environmental impact assessments, also somewhat tangentially. And of course, as we heard, the protocol also requires that activities in the Antarctic Treaty Area be planned to limit adverse environmental impacts and underscores a series of harms to avoid, including degradation of areas with biological, scientific, historic, aesthetic, or wilderness significance. And as I mentioned, it requires a prior impact assessment and gives priority to science and to preserving the value of Antarctica for research. So those are very progressive requirements that still apply. Second point is, where does Antarctica's intrinsic value reside? Think of it as the essence of Antarctica, what makes Antarctica what it is. And this includes the Antarctic marine ecosystems and environment. Since Aristotle, we understand that the whole is greater than the sum of the parts. And when we apply this to Antarctica, this means that intrinsic value can be reduced to a simple list of attributes, like a penguin's krill, sea ice, ice sheets, ice shelves, etc. Rather, that value emerges from the whole environment, or in some views, from the whole of Antarctica itself. Now, if the whole matters, then protecting intrinsic value should shape every human interaction with the Antarctic. This isn't an argument to halt all activity. Rather, it's a reminder that we can protect a few components as representative of intrinsic value, while treating others as mere resources for exploitation. And that contradiction is most evident in the Southern Ocean surrounding Antarctica. The Convention on the Conservation of Antarctic Marine Living Resources, CAMELAR, which applies to Antarctica's surrounding waters, doesn't mention intrinsic value. And it defines conservation as including rational use, underscoring, in fact, its instrumental focus. However, CAMELAR recognizes the Antarctic marine ecosystem, which is referred to as marine living resources, as comprising all living species south of the Antarctic convergence, together with the interconnected relationships among species and with their physical environment. It also requires that fishing should not cause irreversible damage. So the Convention, despite its instrumental focus, carries a strong ecosystem and precautionary focus as well. Now, CAMELAR is a conservation convention, not just a fisheries body. Yet in practice, it often stays focused on instrumental values and uses, notably through the krill fishery. Krill is fished largely for non-essential purposes like dietary supplements and pet food and feed for farmed salmon. Fishing is regulated, but krill fishing nations show strong interest in raising catch limits. I mention this because krill is important for the Southern Ocean food web and carbon sequestration, for instance. Yet the fisheries targets the very resource that funds life in the Antarctic. As a krill expert colleague often says, every Antarctic marine creature either eats krill or it's something that eats krill. So that underscores the central role krill plays in the Antarctic marine ecosystem. So I would argue that the integrity and connectivity of the Antarctic marine ecosystem are themselves part of Antarctica's intrinsic value and should be preserved. This fits the intent of the CAMELAR Convention and it's within reach. Many current conservation initiatives sponsored by environmental NGOs, for instance, like protecting 30% of the Southern Ocean by 2030, already have support from many CAMELAR member states. And this protection, if enforced, would have consequential effects for Antarctic ecosystems and the rest of the planet, including as a form of climate change action. We still need consensus from a couple of countries to do that. And third, there is a conceptual convergence between Antarctic intrinsic value as framed in the protocol, the Cameron Convention ecosystem-based focus, and growing efforts to recognize Antarctica as a living community of species, of which we have heard some already and will hear more shortly. And we have heard already about the Resolution 854, recognition of the rights of Antarctica, which encourages IUCN members to strengthen cooperation under the Antarctic Treaty System to protect the intrinsic value of Antarctica and its dependent and associated ecosystems. This resolution underscores the conceptual link between Antarctic intrinsic value and its recognition as a distinct living component of the Earth system. Conceptually, we can also extend this cooperation beyond the Antarctic Treaty System as well. So where does this leave us? Efforts to protect Antarctica's intrinsic value remain practical but fragmented, and especially limited at sea, a gap that will only grow as human pressure increases. So intrinsic value can serve as a common ground across legal, ethical, and philosophical perspectives, and across stakeholder groups and epistemic communities. So in this sense, I regard it as a very valuable concept. Now, what can law change? I mean, there was a question posed at the beginning. I think whatever lens we adopt, our responsibility is the same, which is to preserve the heart of Antarctica, what makes it what it is, for its own sake and for future generations, human and non-human. I think also this is within our grasp. The legal bases are partly in place. We need now to implement them and enhance them as necessary. Thank you.
Thank you, Ricardo. And thank you for the opportunity to share some thoughts on Antarctica's intrinsic value and inherent rights. My name again is Linda Sheehan, and I'm with Environment Now, and I'm happy to be associated with some of this work to advance the well-being of Antarctica. I'd like to pick up from Ricardo's remarks on intrinsic value and talk about rights. Rights in part represent a legal expression of the philosophy of intrinsic value, which itself, as we heard, reflects the moral worth of Antarctica. We protect Antarctica because it's the right thing to do for its own sake and not just a way to meet human needs. As we heard earlier, the IUCN has a long history of recognizing the rights of nature as a legal acknowledgement of the intrinsic value of natural systems and species. So, for example, in 2012, IUCN Resolution 100 called on the Director General and members to promote the development of the Universal Declaration of the Rights of Nature and to initiate a process that integrates rights of nature in all areas of IUCN decision-making. And then the World Commission on Environmental Law in 2016 issued a declaration on the environmental rule of law, which carried this forward. Its first principle recognized intrinsic value by articulating an obligation to promote the well-being of nature regardless of its worth to humans, and paired that with the principle that nature has the inherent right to exist, thrive, and evolve. Since then, the rights of nature have been recognized in various forms of law and policy in dozens of nations. Implementation of those rights is already beginning to have real impacts on the ground around the world. Notably, the IUCN released a new Antarctica and Southern Ocean strategy last September that also references the rights of nature, prioritizing the responsibility to advocate for other species in ecosystems and their inherent right to exist. Like Resolution 54, which we've heard about, the new Antarctic strategy sets a goal to improve international cooperation within the Antarctic Treaty System. It states that business as usual cannot continue, or else ecosystems will collapse while we're tiptoeing around the edge, particularly around the edge of geopolitics. The strategy itself calls for new innovative approaches for the conservation of Antarctica, both within and outside the Antarctic Treaty System. The IUCN's Rights of Antarctica Resolution 54, which was adopted the next month, reinforces and expands on the language in the strategy. It asks the Director General, IUCN members, and partners to thoroughly evaluate the concept of the fundamental rights of Antarctica and the corresponding duties of humans, which is what we're doing today, starting this conversation. In doing so, the resolution reinforces the Madrid Protocol's recognition of Antarctica's intrinsic value by suggesting new innovative approaches to help slow accelerating threats like climate change, as called for in the IUCN's Antarctic Strategy. Resolution 54 arose in large part from the concerted efforts of Antarctic experts like Ricardo, nature's rights movement leaders, indigenous leaders, artists, academics, and others to address the growing threats to the integrity of Antarctica and Antarctic beings. Many of these international experts and advocates have also worked together to develop and open for comment a draft Antarctic Declaration. This declaration addresses the potential expression of the rights of Antarctica in law and offers a detailed call for these rights for all Antarctic beings and for humanity's responsibility to protect and respect those rights. So with that, I would like to just share my screen. Just to show a couple of these, what we heard, I promised were photogenic slides, and I don't think I lied. There we go. Start the slideshow. So these is just a couple of highlights from this Antarctica Declaration, which you can find at the website at the bottom of this slide, and I'll reinforce that at the very end here, antarcticrights.org. But the declaration itself suggests transformative changes that include recognizing Antarctica as an autonomous, self-regulating, sovereign entity and respecting and upholding the inherent rights of Antarctica and Antarctic beings, and ensuring that Antarctica itself is represented in the decision-making that affects it, and that such decisions are based on what is best for Antarctica. So as you see here, here's a couple of reflections of these concepts regarding the legal status of Antarctica as an independent autonomous entity with a unique international legal status, as we heard earlier. Reinforcing the rights and freedoms of Antarctica, and including the right to exist and maintain identity and integrity, and referencing that it is self-regulating but also intimately connected, as we just heard from Ricardo, to all of us, and it impacts us as we impact it. And then again, referencing the duties that go with our professed rights to a healthy environment and other rights. We need to respect and protect the beauty and intrinsic value of Antarctica and Antarctic beings. A couple of other highlights from the draft provisions. Decision-making is critical, and making sure that Antarctica is represented effectively in this decision-making. The IUCN's massive expertise in science and law and policy has helped it become, in part, a voice for Antarctica. And I think that that's something that we can all share that responsibility and duty for, to make sure that Antarctica is represented. And that in implementation, that Antarctica's best interests are identified and considered strongly in any decision making. So again, reflecting that idea of intrinsic value. So recognition in law of these legal rights is important because it sets a standard for holding us all accountable for infringing on Antarctic rights, and it starts to create a structure for us to be able to do that. And the declaration, the Antarctic Declaration, is open. It's a draft. It's open for comment. It's the start of a discussion and the start of a movement to be able to recognize Antarctica. There was an alliance of organizations and individuals launched last December, Antarctica Day, and that alliance is welcoming comments right now on the declaration. The declaration itself will be adopted on December 1st, Antarctica Day this year, in Cape Town, South Africa, which is South Africa is actually one of the original treaty signatories, the Antarctica Treaty, and is the only Antarctic Treaty System consultative party in Africa. So you can access that information either through the website, or hopefully you've captured the QR code here. So I'll stop sharing and head back to quickly summarize the last bit of my remarks. Make sure that that's stopped. Great. One just very last point to reinforce is that the Antarctic Declaration that we just heard about complements and supports the goal of the Antarctic Treaty System. It's similar to the way the Universal Declaration of Human Rights in 1948 did not replace international law, but instead offered standards that would help guide the evolution of existing laws to advance agreed upon norms. Recognition of Antarctica's fundamental rights through an Antarctic Declaration likewise can help guide legal advances grounded in intrinsic value that increase needed protections for Antarctica and Antarctic beings. So this declaration is an important step forward in the effort to safeguard Antarctica and recognize and protect both its value and its rights. And I hope that all interested listeners will review and share their thoughts on it. So now I'd like to turn over to Cormac Cullinan, Executive Director of Wildlaw Institute in Cape Town.
Thanks very much, Linda. So I'm an environmental attorney by profession, but also director of the Wildlaw Institute, as you heard. And the Wildlaw Institute serves as the secretariat of the Antarctic Alliance, which has been driving this Antarctic Rights Alliance. So because we want to leave time for questions and discussion, I'm only going to make 6 points. First of all, starting off the context, explaining a little bit more about why the reasons for this initiative, and then addressing the relationship between the Charter and the Antarctic Treaty System. So first of all, the context. I was very influenced by the work of Thomas Berry, and Thomas Berry said the union is the communion of subjects, not a collection of objects. Now, what that effectively means is that we don't live on Earth. We coexist with other beings within the Earth community. We are part of nature. We are inside the system. But most legal systems are based on the scientifically indefensible belief that humans are separate from and superior to the other members of the Earth community, or nature, if you like. Now, the Global Rights of Nature movement, some of you will be familiar with, seeks to correct that historic error. And seeks to bring about a situation where legal systems recognize the ecological reality that we are all interrelated and interdependent. And that means that human beings must play their part in maintaining and enhancing the beauty and integrity and good functioning of the whole Earth community. And we believe that in order to do that, we need to first start off by recognizing that other beings, whether they be animals or trees or rivers, are subjects with inherent rights, which arise by virtue of the fact that they exist as part of this community of life, just as we humans claim to have inherent human rights because of our existence, even if our government denies us those rights. So that's, in a sense, the context or the starting point for this initiative. But moving on to what's the point of it? As you've heard, Antarctica merits protection for its own sake, as well as for the benefit of the whole Earth community and for other members of that community, such as human beings. So, as everybody knows, I think Antarctica is this awe-inspiring, unique and critical aspect of a system of order that evolved over millions of years and brought about the stability of the Holocene epoch within which our species developed. It's also, that stability has also enabled the life to flourish in an amazing profusion of different life forms. And I think that means it really has got intrinsic value and merits protection from being disrupted by humans. The question, though, is how best to do that. Now, the Antarctic Treaty itself and the subsequent Camelot Treaty were groundbreaking. They really were extraordinary treaties at the time, and they have been crucial in the protection of Antarctica. But now we can see in the 21st century that protecting Antarctica is going to require more than them. For example, as you've already heard, the greatest threat to Antarctica is climate breakdown, which is caused by activities which occur outside the treaty area, in other words, beyond the jurisdictional limits of the ATS. Also, for many years, conservation initiatives within the treaty system have been blocked for political reasons, despite the fact that those initiatives, such as declaring new marine protected areas, would have been beneficial for Antarctica. In other words, the decisions are being made on the basis of the political interests of the member state, of the consultative parties, the states, not on the basis of the best interests of Antarctica. And we believe that we now have to recognize the reality that Antarctica is a living community of enormous intrinsic value. And it's valuable to all people as well as other beings around the world, and that our governance systems need to reflect that, and need particularly to reflect what humans must do, in other words, the duties of humans, to stop harming Antarctica. So what we're saying is that this is an evolutionary step, if I can put it that way, in the protection of Antarctica. So then moving to the relationship between the proposed Antarctica Declaration and the Antarctic Treaty System. The first point is that the Antarctica Declaration does not seek to replace the Antarctic Treaty System. It takes a very different approach and serves a different purpose. Now, if you think about the Antarctic treaties, like all treaties, they're essentially agreements between the contracting parties. Whereas, as Linda has already explained, this declaration is not about an agreement between contracting parties. It's about the inherent rights of Antarctic and Antarctic beings and the corresponding duties that those rights give rise to. In other words, it creates duties for all humans, not just as the state signatories to the documents. Perhaps more accurately, it recognizes that we have those duties because those duties arise from the reality of the situation, that we are dependent on Antarctica for the stability of the climate and many other, and the circulation of global currents, etc., many other aspects. So another difference is the primary focus of the Antarctic Treaty System is just to establish a governance system for Antarctica. In other words, it defines how decisions about Antarctica are made, who's at the table, and it defines how human activities within Antarctica are managed. The Declaration, on the other hand, has a different focus. Its focus is on defining the legal status and the rights of that ecological community, Antarctica as a whole, and also of the individual beings that make it up. In other words, all the beings that are part of the continent or within the Southern Ocean, and how that changes how people relate to them. So in other words, as soon as those beings are recognized as legal subjects with rights, it will create corresponding obligations on humans. So it's really primarily about defining those fundamental legal statuses, rights and duties, as opposed to establishing the governance system, which you see being established under the ATS. But I think perhaps most importantly is the fact that the ATS and the Antarctic Declaration see Antarctica differently. So under the ATS, Antarctica is seen as a place for peaceful scientific collaboration. So from this perspective, it makes complete sense for the decisions to be made by those states who are engaged in that research, in other words, the consultative parties, and to focus on managing what people do in Antarctica within the treaty area. However, if Antarctica is seen as a subject, which most people have an impact on, if only via climate change, and that subject is of vital importance to maintaining the conditions which have enabled life to flourish, then the focus shifts to how everybody relates to Antarctica as a living community. In other words, from this perspective, Antarctica is not a place for scientists to go to and study and to be managed. It's about establishing a global community of people who take responsibility for protecting Antarctica. So that means that the Antarctic Alliance will actually focus most of its energies on changing human perceptions and on changing human behavior outside of Antarctica that affects Antarctica, as opposed to managing. It's not that management within Antarctica is irrelevant. It's just that the main focus is on what happens outside Antarctica that affects Antarctica. So to conclude, whether one agrees with our proposition, this initiative, which we believe is based on a scientifically correct understanding of how the planet works, as opposed to the fiction that we are separate from and superior to nature. So even if you don't totally accept that, I think at the very least, this initiative is an extremely valuable experiment in creating human institutions that are fit for purpose in the 21st century. So just to explain what I mean by that, currently intergovernmental institutions decide how make the governance decisions which regulate human behavior at the global level. Now, obviously, these international institutions are established by way of treaties between states, and they reflect state interests. If states don't want to set them up or don't believe in them, they won't be parties to the treaty. But the fact that they are set up by states gives them power, because the states which establishment can translate their decisions into binding international law, and they can also enact national laws to implement international laws and policies within their own territories. So it gives them certain advantages. But what the Antarctic Alliance is trying to do is something quite different. What we are doing is we're experimenting and innovating in order to facilitate the emergence of governance systems that are appropriate for Earth. In other words, systems that are aligned with the realities of the Earth community and that seek to regulate people, not merely as citizens of national states, but as members of the Earth community who have a responsibility to that whole community as a source of life. Thank you.
Thank you very much. So I guess at this point, we'll open the Q&A, and I see I would invite our esteemed speakers and experts to address some of the questions that have been written in the Q&A part of this webinar. There are, for example, I see some of them were already answered by writing, but this is also an opportunity to address them orally if you so wish. For example, not to point the esteemed experts in one specific direction, but one I can see right now open in the Q&A is from Hugo Echevarria from Ecuador, who's very proud of Ecuador having been the first country recognizing and applying the rights of nature, as he indicates. And he has a question for all in the panel, referring to the Inter-American Court that in 2025 recognized nature as a subject of rights in the advisory opinion 3225, highlighting this big importance to address the triple planetary crisis. And the question he asks is, since some of the consulting parties of the Antarctic Treaty are also parties of the treaties governing the Inter-American system, what should be the impact of the specific advisory opinion in assessing the role and the rights of nature in the Antarctica context, if any? And I see a hand raised from Cormac. Please, the floor is yours. Thank you.
Thank you very much. Yes, I think that's a great question from Hugo, and a very, very interesting one. So essentially, the advisory opinion, among other things, recognizes that if certain human rights are mandatory, it's mandatory to protect them under international law, and those rights can only be effectively protected by also protecting the ecosystems which are necessary to sustain the human life and those rights. Then protecting those ecosystems must, as a matter of logic, be mandatory as well under international law. And then it goes on also to say that rights of nature is an effective means of addressing climate change and protecting these ecosystems, and also the associated rights of indigenous people. Now, as Hugo, I think, is very well aware, this is particular. If you apply that logic to Antarctica, and you've got some countries, including Ecuador, who are participating in the Antarctic Treaty System, it seems to me entirely logical that they should extend their appreciation for rights of nature, or the recognition that's coming from the Inter-American Court that this is an effective tool, to Antarctica itself. In other words, I would argue that one of the implications of that advisory opinion is is that the implications are not just confined to what you do within your country, but should apply equally. So I would look forward to the day when countries like Ecuador, through their participation in the ATS, promote the idea that Antarctica and Antarctic beings has inherent rights, just as nature does within Ecuador.
Thank you very much, Cormac. There's a series of questions that have already been answered, but just for the interest of everyone, there was a question about whether there will be a recording available, and it was addressed. The recording indeed will be available. And there was also a question about specific references to the IUCN resolutions that were indicated in some of the remarks, and Dr. Bhati indicated those references. There was also a question regarding what other action envisioned as necessary for WCEL IUCN to undertake in order to implement a resolution and thoroughly examine the right of Antarctica. And Linda referred to the important work around the Antarctic Declaration and the explanatory memo with the link. There was also a technical issue regarding the presentation with the beautiful pictures, but that was directly shared again in the answered questions. Now, as for the questions yet to be answered, there's a question from Irina Rose about the thoughts of the panel on Kaitia Kitanga. Open again, I'll take a few, and then everybody will be, of course, in the panel open to address whichever they choose. There's a question as well from Gary Friedlander, who's asking if the group has considered obtaining status of a UN member state for nature, specifically through sovereignty over unclaimed territory, e.g. Mary Bird Land, and he indicates that he had contributed to a paper on obtaining that, along with different paths to obtaining greater recognition at the UN of the rights of nature. Andrew Kelly is asking if Antarctica is recognized as a rights holder, how would that recognition become operational inside the ATS? Who would represent Antarctica, with what authority, and could this right constrain or overcome a state's use of consensus to block protective action? Horacio Werner is asking if he's saying that he would appreciate if one of the experts in the panel could clarify if the intention is the effect of the declaration to coexist with the ATS, and if so, how would that work in terms of governance? Leslie Adams is asking, would considering the way of working for the International Space Station be of any relevance? Sophie Lloyd is asking, challenging the panel to talk a bit more about political will. Has there been consistent or inconsistent support from states in different form? And Elahe Rashbiani is asking if the panel could elaborate a bit about representation and accountability mechanisms. And I see Linda has her hand raised. Please, Linda, the floor is yours.
Sure, thank you. And these are all excellent questions, and I'll answer a couple of them briefly just because they sort of jumped out at me, and I know that Cormac and Ricardo would be experts on some of the other ones. But looking at Leslie Adams and Sophie Lloyd's questions, I think that Leslie Adams raises a great point about looking at other models for how we think about moving forward in governance. Space is certainly another area that is similar to Antarctica in many ways, in that it's a shared political space. There are agreements that have been worked out to work together, and those agreements are facing some pressures that perhaps weren't thought of when they were originally drafted. In the late 50s. So there's a lot of opportunity there to work across these different areas. And so I think that that's an ongoing conversation. And then Sophie Lloyd's question about talking more about political will. When I glanced at that, what I was thinking was more about Antarctica's political will. And what is the expression of Antarctica's political will, and how do we hear and represent what that is? Certainly with regard to climate change is one way that Antarctica expresses its own will. But there are numerous others, and Ricardo talked about the krill fisheries. But in terms of support from states in different fora, there have been, initial indications of some support, some curiosity, some concerns. But the fact that the resolution 54 passed in a multilateral convening in the Congress last fall is strong indication that there's a lot of openness to discussion and thinking about how we have a stronger relationship with Antarctica moving forward.
Thank you very much. We haven't heard from Cormac and Linda. Before I revert again to our other experts, there was one other question that was raised, more general, an anonymous attendee who's asking, in the experience of the panel, what is the biggest challenge in raising public awareness of the rights of nature movement? So I'm looking at Philippe, Harsh, and Ricardo. If one of you would like to take that, or all of you. Don't see any hand raised at that point, unless I'm mistaken. Ricardo has unmuted himself. Please go ahead. Yes.
I actually didn't have an answer for that specific question. I think, anyway, I think my answer was more generic, and to me, there is an issue of time. I'm not a historian. Originally I was a geologist, so I have a keen sense of time and the effect time has on nature and on life. So I think it took time, of course, to develop the Antarctic ecosystem, as Cormac mentioned. It took time for humankind to enter the Anthropocene period in which we are now. It took time to establish the Antarctic Treaty System, and it will take time to establish rights of nature globally and in Antarctica as well. But that doesn't mean that all periods work at the same speed. I think we will get into that. I think there were some questions there as well to the effect of how the current Antarctic Treaty System will relate to that. Of course, I don't know, but what I know is that there are a number of countries within the Antarctic Treaty System that already recognize domestically or nationally rights of nature. And I think they will be free to bring some ideas to the treaty system itself or to the Antarctic operations. And let's not forget that even though the Antarctic Treaty System makes decisions, common decisions by consensus, countries are quite free to take their own initiatives within the constraints, of course, of the legal regime we have. So I think it will take a time to get all these stages. And you made a very good point at the beginning, Ayman, concerning a declaration. It could be just a statement or could become a regime. And I think that to take that step will take quite some time, but we will get there eventually. I don't know when, maybe it's in 5 years, 10 years, or more time, I don't know. But I think we will get there, and the direction is travel is in that direction, effectively.
Much. And your comments about time, Ricardo, remind me of a beautiful French song from Léo Ferré. Où time goes, everything goes. Avec le temps va, tout s'en va. I see Cormac has his hand raised, but I saw Harsh had at some point raised his hand as well. I'm happy to give him the floor, and then we can go back to Cormac. Harsh, please.
Thank you. I'll take the biggest challenge in raising public awareness. I mean, like when it comes to rights of nature, especially like it is often misunderstood as a symbolic or purely philosophical ideas rather than something legal and governance approach, which has taken place and started to take place, not just in a legislative form, but itself in the constitution, such as Ecuador, what Hugo was mentioning earlier. So many people, like when they hear nature has rights, then they immediately ask like, oh, whether this means like putting nature above people or stopping all human activities. But like the awareness challenge is to explain that rights of nature is not about excluding humans from nature, but about the changing the terms of our relationship with nature. We have always treated nature as an object, and now the rights of nature is trying to change the scenario from like taking them out from the object and putting them in the subject category, similar to humans. So basically, like from ownership, extraction, management, we take out and then we put transition them into duties of care, restraint, restoration, and representation. And especially if we talk about Antarctica, the challenge is even sharper, as the panel has mentioned in their discussion. because Antarctica feels distant from so many people. No human communities have been active, like except the research and the scientific communities. But in general, the lack of presence makes it sounds that, oh, Antarctica is distant from us. But the Antarctica is deeply connected to all of us through climate stability, ocean circulation, sea level rise, biodiversity, and planetary system. So public awareness has to make this connection visible, that Antarctica is not remote from our lives. It is part of the Earth system that makes our lives possible. So I think like working on these aspects would help us get over the challenges when it comes to raising public awareness on rights of nature.
Thank you. Thank you very much. And before we revert back to Cormac, who had his hand raised earlier, I see a couple of additional questions did emerge in the Q&A. One is technical from Leslie, and I think Roberto will be addressing that because I'm assuming it's a technical issue. Then I see one from Medeliev Eshkeblum, who's asking what kind of precedent will the recognition of rights of Antarctica set? What might be the next steps from an international perspective, and what opportunities might be created? I see one from Scott Hedjoft, who's ASOC board vice chair representing ASOC and IUCN at Abu Dhabi World Conservation Congress, including in the Resolution 54 contact group. He's also a member of the IUCN Antarctic and Southern Ocean Task Force, and is indicated that ASOC was successful in anchoring Antarctica and the Southern Ocean into the IUCN 20-year vision, new program and commission mandates. A question for the commission: how is it coordinating with the IUCN Secretary Lead for Antarctica and Resolution 54 and IUCN ASO Task Force? I think that will be mostly directed to Philippe or Harsh. Happy also to react if helpful and appropriate. And there was, sorry, I think there was another one. Yes, from Victor David. In which court would Antarctica's rights be subject to jurisdiction? And happy now to go back to Cormac, who had his hand raised earlier. Thank you.
Thank you, Ayman. I'll try and be quick. So if Antarctica were accepted as by a country anywhere in the world as a legal subject, then it could be represented in those courts. Equally, if it were accepted as a subject of international law, then it would be entitled to a seat at the table at various international, within the UN system or within the Antarctic Treaty System. But at the moment, that's not the case. So Antarctica does not have a seat at any table, governance table. The people sitting at those governance tables talking about Antarctica are sitting there as representatives of states. But a lot of the questions I noticed correctly focused on how could Antarctica be represented in these decision-making structures? And that's a long and complex question. And we think it's such an important question about how do we as humans learn how to listen to aspects of nature and faithfully represent what we learn from that listening in human decision-making systems so that they can be taken into account in human decision-making. And so after the Antarctic Declaration is signed on the 1st of December, we will shift to working out how to make this, how to establish processes and institutions, etc., that can listen with integrity and take those forward into human decision-making, because our ability to do that will determine the legitimacy of the system to a large extent. Are we able to do it best? But we don't want to rush to an answer, because we want a wide, inclusive process, because we think it's an incredibly important question which affects not just Antarctica, but our relationship with all aspects of nature. Thank you.
Thank you. Thank you very much. And I believe we only have a few more minutes before we are at the end of our scheduled time for this very interesting webinar. At least, sorry for being biased. I did find it most interesting. So let me see if I have further reactions from the floor, additional questions. I do see one from Horacio Werner, who's asking, besides the obvious ethical and natural right dimension, which one is the concrete short midterm problem the Antarctic resolution aims to solve, if any? With the Horacio is with the Agenda Antarctica Foundation. Let me have a look if somebody would like to take this question. And I think it may very well be the last question before I give the floor back to Philippe and Harsh, the leadership of a specialist group on this issue, to close off this webinar. So let me see if anybody would like to address this. I don't see any hand raised. Maybe Philippe and Harsh can take it on as they close us off. If not, I also very much encourage the experts in the panel to also engage in writing with the questions. I am not seeing any hand raised. I'm happy to give the floor back to Philippe, please. Thank you.
I think Ricardo has unmuted. So.
Oh, sorry, I didn't see that. Yeah, Ricardo, please.
Yes, I don't know that I have an answer. I think, I mean, I know Horacio wanted to answer personally to him. I think the concrete problem is the way we as humankind deal with the Antarctic. And that applies both, I mean, within the Antarctic Treaty System as we know it, and also in the declaration. They both have their own answers in a way. So I wouldn't necessarily see the declaration resolving a short-term problem or a medium-term problem. I think it's more of a philosophical perspective with a longer time horizon to do things. It will be a change in the way we relate to the Antarctica. If we don't see it in Antarctica, we will see it elsewhere as well. So yeah, I wouldn't see the declaration as a panacea to all the problems of the Antarctic. But I think in time, a change of perspective will improve things for the Antarctic, hopefully, and hopefully also for other beings, including human beings. Thanks.
Ricardo, now I believe the virtual floor is yours, Philippe. Thank you.
Okay, thank you. So I'll first address that very specific question. As I guess you know, WCEL and the Secretariat are technically linked, but also very much distinct. So we've started engaging with the Secretariat on trying to work with them for the timing. This is an ongoing conversation that started only a couple of months ago, but we are definitely working on that. Now, okay, 1 hour was never going to be enough to address all the dimensions of the topic, but being focused is always very good also. I guess there is really nothing quite like Antarctica in the sense that it's very different from the other rights of nature debates we're having at the Global Commons, the lack of permanent habitation, the kind of human habitation, sorry. The kind of different things that we can extract from a discussion around rights of nature in Antarctica. So the initiative around the Antarctica Declaration is obviously amazing in terms of making us focus on all these different dimensions. I'm sure there are lots of remaining questions that need to be further addressed, as Cormac just told us very directly. So for now, since we're out of time, I think I'm just left to thank our three experts for taking the time to be with us, and to all our participants, as well as our Deputy Chair, Ayman, for chairing this webinar, and also Roberto, who is in the background and has made this possible for us. Thank you.